Okay, so I'm going to be talking about speech rights, kind of where are we now, and I'm going to give a super quick overview of where we've been and talk a little bit about where I see the next big speech rights struggles coming up, and in particular in relationship to the internet. But I think in many ways it applies across other what I'm calling multi-channel media as well. So I'll just say to begin with that I approach the question of speech rights from the perspective of someone who's a media access advocate. I'm really interested in ordinary people having better access to the media than they do. I think that media are really central to democratic political communication. I think they're critical forums of opinion formation, and that who can speak in the media and under what conditions are really critical questions in democratic societies. So that's kind of where I'm coming from. I'm interested also in what I see as a disjuncture between interpretations of the First Amendment, the major guarantor of speech rights in the US, and conditions that are necessary to protect democratic speech in modern communication systems. And so a lot of my work has analyzed the way that the First Amendment has understood speech rights and tries to consider other ways of thinking about speech rights, still kind of within a liberal democratic framework, but one that could better protect free speech. And so, First Amendment, as I said, is really the major guarantor of speech rights in U.S. society. It's hard to have kind of other models or other frameworks for thinking about speech rights that stand outside of the First Amendment and how it thinks about issues, or how we think about issues of rights within the kind of liberal democratic approach. But the history of the First Amendment and how it's interpreted has been a really contentious question. And I want to say I think there have been, this is really small, kind of three phases in thinking about free speech. And I should just preface this by saying that we have this First Amendment to our Constitution, which literally is around for at least 100 years, and really no law is made with it. So you have this thing, the First Amendment, but it doesn't develop in any way. People don't really apply it to anything for almost the first 100 years of its existence. And it's not until the 1930s and 1940s that you start to have questions about, well, does the First Amendment apply? And in this case, the 1930s and 1940s, does it apply in what I'm calling unmediated spaces, real spaces in the real world that people have access to? And really, it becomes a question in the 30s and 40s, largely because of the labor movement, but also because of other progressive groups that are out there that are seeking a right to speak in public spaces. And this is something they feel like they can't organize, and they can't do their political work without having the opportunity to pass out flyers or to talk to people on the streets. And they argue that speech rights are really useless if you don't have some kind of practical opportunity to speak. So you have, after 100 years of nothing particularly much with the First Amendment, you have this idea of public space that kind of comes about in the 1930s and 1940s, something that's called public forum law, and I guess I'm actually kind of getting beside myself here. But you, for the first time, have the kind of rights to speak in public space. But it's really understood as rights to speak in traditional public spaces. These are spaces like street corners and public parks. And you have the origin of what's called public forum law, which is kind of a really problematic area of law. But unfortunately, it's the area of law that we have to think about when we think about questions of public space. So basically, you have Hague versus CIO, a case in 1939, and for the first time, you have kind of public forum law and speech in public unmediated spaces. After that, you really don't have that much that deals with kind of speech rights in the media until the 1960s and 1970s, when you enter that kind of second phase, which I'm calling, access to single-channel media. And what I mean by that is, people who have maybe a newspaper or they run a broadcast station, and people are trying to get access, and the courts are for the first time being asked to consider what kinds of rights exist in that space. Does the public have any rights in that space, or do all the rights really belong to the media owners in terms of speech in print and in broadcasting? And in the 1960s and the 1970s, again, there's kind of a range of social movements, including the anti-war movement, that bring these questions into the courts. So 1960s and 1970s, the central question before the court is whether the public should have speech rights in these kinds of single-channel media. And many people thought at the time there was kind of a media access movement, and people thought that media had replaced public parks and street corners as relevant sites for participation and public discussion in democratic processes. And even though they were privately owned, the argument was that they have a public function in democratic societies and that you have to have some kind of public speech rights there. So there were a number of cases that kind of looked at single-channel media in the 1960s and, well, late 60s, early 70s. And unfortunately, I think these cases left citizens with almost virtually no opportunity to kind of speak in the media, not much by the way of speech rights in the media as opposed to the media owners. And basically the way it kind of shook up through these cases, and I won't get into the details of them, but was that the public really has no right to speak or any kind of access rights in relationship to newspapers, and they have a very limited kind of access right in relationship to broadcasting, single-channel broadcasting. They have a right to receive information, but they don't have any kind of right to speak. So that's the 1960s and 1970s. And the cases are kind of listed there, but I won't really go into them. And now you have what I would say is sort of the third phase of thinking about what kinds of speech rights the public might have in the media, and that's what kind of rights we have in multi-channel media or broadband media. So now that you have these kind of media entities out there, these corporations that own and really are not sort of speaking over one channel, but over 150 or 200 or 300 channels, can there be said to be any kind of public speech right in those spaces? So the question of whether the public should have speech rights in the media continues, but now it continues in this form of thinking about it in terms of these kind of multi-channel and broadband operators. And when I say that, I include cable TV, which is really, to me, the first broadband kind of multi-channel media, and these questions started coming up in relationship to cable TV in the 1990s, really. They've come up a little bit in relation to satellite, but not necessarily in the courts. And then, of course, the internet. And what I'll say is with satellite and with cable, the issue is really, can governments make regulations that are kind of content neutral, but that might mandate access to entire channels on that system operator's sort of array of channels. And in relationship to the internet, the questions are somewhat different. We're not really dealing with channels anymore, but they have to do with, who are the speakers on the internet? Who really has the right to speak there? Who can be shut down? And who has the opportunity to speak? And really, the courts have not yet decided this question, but I'm kind of thinking about it anyway, looking at it anyway, and sort of thinking about some of the cases that have come into the courts at the lower levels, and one Supreme Court case so far that really are beginning to address this issue. And so I think the courts are an interesting place to look at the question of public space in the media. I think they deal with, or they sort of, problems come to them, conflicts come to them before they're oftentimes in kind of the public's mind. And so this is kind of what I decided to look at. And really the central question now, can public space exist on multi-channel media? And I would say, the internet, too, I consider it to be a kind of hybrid space in the same way that satellite and cable are a hybrid space. It can accommodate many different kinds of speech. It's doing it on sort of many different spaces at once. And I just want to give a little bit of an overview and context. I'm really going to skip over a lot of what I've been thinking about in terms of the sort of philosophical approach I'm taking and the kind of larger analytical approach. But part of what I'm thinking about here is normative and actual dimensions of public space, in the same way that we might think about normative civil society versus actual civil society, kind of practiced applied civil society. You have sort of the normative idea of public space, and then you have sort of the real actuality, the legality as well of public space. And so for thinking about normativity and normative public space, I've been looking at John Dewey, and Benjamin Barber, and Habermas, who all in various ways identify public spaces as essential elements of democratic society. These are the spaces where people can circulate information and ideas that help them develop some kind of common understanding of the common good. They are the spaces that enable and legitimize self-governance. And the virtual spaces, I think the virtual spaces of the media, as well as physical spaces, are kind of vital forums in this respect. People have to have some kind of right to communicate in these spaces, I think at least some of the time, and that's really what the normative theory posits. And in the U.S., public forum law, which I've kind of already alluded to, and I'll get a little bit more into it just to give you kind of the enough that you would need to know to kind of think about this. Public forum law is really the primary means of thinking about public space and of protecting public spaces where the public can potentially have speech rights, or the public's right to speak can be operative. But the law around public space has developed in such a way that generally the people who have rights to speak, even in spaces that we might think of as government-owned or semi-public or having a public function, are essentially private owners or public managers of those spaces or those properties. So the law has developed in this way and more or less allowed private owners, or now increasingly public managers of space, to exclude other people from this kind of property. And so the issue here is really that if you don't control or have the access to resources and spaces, you either have to ask owners for access to their property, and usually that comes at a cost, or you have to use spaces that the law kind of declares are publicly available for expressive purposes. And of course, the problem with not having enough public space is that viewpoints that are poorly financed or controversial or unpopular or challenge the status quo in some way may find few opportunities to speak outside of these spaces that may be legally sanctioned public spaces. So this is kind of why I'm interested in this issue. And I also think that the viability of public space in the media really hinges on how we understand its legitimation in law. And what's interesting, and I really won't get into this, but there's sort of been policies that have created elements of public space in some of these multi-channel media that the courts have allowed to exist there, but at the same time they haven't really kind of affirmatively said that the public has rights to speak in those spaces, even though they may not always strike down those policies. So there's this kind of uneasy tension in which sort of public space currently exists, I think, in the media, in the few places that it does exist. So the U.S. Supreme Court has been very ambivalent about claims that public spaces exist in established media, or that people have any kind of rights to speak there, and often has basically found little or no rights in print and broadcast and cable television, even though they've allowed things like community access channels to exist. So I just kind of want to make that caveat up front. So what I do in this work is I look at the legal status of public space and public speech rights on the internet, and I try to look at cases that address whether public space exists online, whether any public space can be said to exist on the internet, and whether the public can be said to have any speech rights there. And I'll kind of get into why I think this is important, although we can debate this. But as I said, a number of lower court cases and at least one Supreme Court case have dealt with this question. And what I find in looking at these cases is, again, a gap between normative democratic theory and the actual legal practice surrounding public space that, for me, casts some doubt on kind of optimistic visions of what the internet could be, and causes me to worry a little bit about how ideal of a space the internet could be for democratic communication. So thus far, public forum law has really not recognized public space in which public speech rights might exist on the internet, and it might even, in its current incarnation, inhibit policies that try to support kind of public spheres of discussion, or maybe even limited rights of access online. And then I sort of conclude by discussing some alternatives, and I kind of try to broaden them out a little bit too, to consider some of the concerns of people here at this conference. So I want to, as I said, kind of skip over the philosophy and get right to the ground, I guess, and talk a little bit about public forum law, just so you kind of have an understanding of what that is if you don't already know. Public forum law, basically from the 1930s to the 1960s, this is the law that kind of creates the idea of public spaces having somehow always magically been there where we had speech rights, even though they weren't really there before public forum law. And between the 1930s and the 1960s, it really does kind of approximates ideals of public space that are set out in democratic theory, and in the 1970s begins to take this kind of regressive turn that I think kind of coincides with the strengthening and kind of rise of neoliberal thinking. And I won't, again, get into that too much, but I think there's a strong parallel between kind of the ascendancy of neoliberalism and what happens to law around public space. So it starts out offering fairly strong protections to speech rights, not just on public property that's kind of considered traditionally to be a public space, but also on private property that's considered to have a public function, which I think was kind of a progressive way to go. But it eventually fails to recognize or protect public discursive space. And basically early public forum law, just in a very broad outline, would do things like weigh the public speech rights very heavily against any government attempts to limit speech. And it upheld the public's right to speak in public space, which was things like streets and alleys and parks and even libraries and courthouses and other kinds of public sites. And It upheld the public's right to speak on private property, as I said, that had a public function. So something like a company-owned town, you would still have speech rights there because even though it was privately owned by the company, it was still seen as having this public function. Or a shopping mall, privately owned space but with a public function, a public gathering place where people might have some kind of speech rights. And both are really seen as the kind of functional equivalent to traditional public spaces at first. That's kind of the progressive direction that the law went. But there were sort of three developments starting around the 1970s, but really much more entrenched in the 1980s around public forum law that marked this kind of regressive turn or this neoliberal turn in how public space is thought about in the law. One was the elimination of this public function rationale, this idea that if it had a public function, it had a public dimension in which people might have rights. Another was the increasing reliance on government intent to determine the extent of government's control over space. And the third was the creation of a legal concept known as a non-public forum, essentially public space that we're going to consider to be, or government-controlled space that we're going to consider to be non-public. So starting in the 1970s, law begins linking public status not to a public function, but more and more actually to formal property characteristics of space. So if it's private property, it's a private space, essentially. And around the same time, public forum law stops weighing the public's rights against the government's and starts privileging government's proprietary interest in public property. And by the 1980s, public forum law identifies public forums pretty strictly according to categories of property. You first decide what kind of category of property you're dealing with, then you know what kind of rights people have there. And today there are basically sort of three categories of public forums, or three categories under public forum law. There's traditional public forums. These are public places that have been considered to have long been used for public expression. But I have to mention it's very much a legal fiction, what can kind of count as a traditional public space. Then there are limited public forums that are essentially public property that the state has opened up deliberately to public expressive activity. And then there are these non-public forums. Wow, okay, which is public property that the state entirely reserves for its own uses. So let's see if I can speed through this too. So modern public forum law, as I said, kind of protects rights in traditional public forums and public spaces that the government deliberately opens up to public expression, but not on private property that might serve a public function or property that's characterized as kind of non-public forums. So I think I might just skip to some of the cases that I want to talk about. I want to look at legality of public space online. And I think law does show how the courts characterize online space, and I was really interested in who has access and whether these are autonomous spaces. And what I meant was relatively independent from government, relatively independent from the market, and what I saw basically was law points right now, and again, this is not made law, but law points towards an internet legal regime that's basically devoid of public space and characterized exclusively by private spaces and proprietary speakers. And so I looked at kind of two categories. One is what we might call, private spaces online. These are spaces that the court definitely thinks are owned by somebody privately, but the question is being raised, does anybody else have rights there? And there are 4 cases that have asked the courts whether these kind of privately controlled spaces might constitute traditional public forums. A couple of them are from the mid-1990s. They deal with internet service providers, attempts to stop commercial spammers from targeting their subscribers. And these really raise the question of whether email might constitute a public space and who has the right to send and receive email through different ISPs. And the spammers basically argued that the public has a right to send email over the net. They say it's a public system with a public function. And the court acknowledged that that might be true. There might be sort of a public component to some degree. But they said the only relevant public functions are those that have always traditionally been the prerogative of the state. And since the state hasn't traditionally always controlled email, the public didn't really have any rights there, and the ISPs didn't have any rights there. So both courts determined that the ISPs are private actors. Sorry, that the spammers don't have rights there. The courts determined that the ISPs are private actors and that their servers are private spaces that they have the right to control, and the only relevant listeners and speakers in these spaces are the server owners and managers, not any third parties and not the ISP customers, both who are seen as having no rights in this context. There was another case that was fought over whether a domain name registrar, Network Solutions, could impose a decency policy on the allocation of second-level domain names. the name to the left of .com or .org, and whether domain names are a public space. And what was interesting is at the time, Network Solutions was the only federally authorized agency, government authorized agency to register domain names, but the court decided that while allocating domain names might be a public function that had always been under the control of the government hadn't specifically asked Network Solutions to implement this policy. Therefore, it wasn't really government action. And moreover, second-level domain names were not a speech forum. They were just kind of a utilitarian pointer. So maybe I should kind of jump. So there's been another one. I'm really going to jump through this. There's been another one that dealt with whether any kind of public speech rights exist in relationship to Google, so essentially search engines. And again, it was decided search engines, private space, public has no right there. Google can exclude people or drop people from search results, and there's really no problem there. Also, I then went and looked at kind of what I would call public online spaces, and what surprised me in looking at the public cases is these are areas where I really thought public forum law would protect speech rights, but it didn't do it any better than it protected speech rights in private space. So there's been a couple of cases. One, Loving versus Boren, a court at the university upheld a University of Oklahoma decision to block university internet access users or access to news groups that might contain obscene material, saying that it's basically the property of the university. They could control how people use it. Nicholas versus Fletcher, where the court said the state of Kentucky could block employee access to websites that might carry disfavored blogs. So the court says that state-owned computers are non-public forums, and they're not there for the free exchange of ideas among the public. In both cases, the courts really treat government-managed space as non-public and allowed government entities to delimit information and communication available to their system's users. Another really interesting case, kind of higher level, federal appeals court considered whether a city could discriminate among those who could link to its website. And the court basically held that the city didn't violate the First Amendment rights of web publishers when it refused to allow them to link to their site, that the publisher maintained that particular publisher maintained a site that was critical of city politics, and that the city's site was not any kind of traditional or designated public forum. As a new technology, the internet was not a site that had always been used for public communication and discussion, so it wasn't a designated public forum as well, in which people had to because people had to obtain permission to link to the site. So according to the court, the site was a non-public forum. The city could impose any kind of reasonable and viewpoint-neutral restrictions they wanted to on it. And what's interesting there to me is that one critic pointed out, this was over whether somebody could link to a government site. One critic pointed out that links are kind of like these interstitial spaces in some ways like streets and sidewalks that allow people to kind of circulate their speech in proximity to other speech, much as you might protest outside of a courthouse, and that is not kind of a protected right online. And then again, I'm really kind of jumping through these, but this was a Supreme Court case, United States versus American Library Association, which asked or raised the question in the context of public library internet access, do users of the internet and public libraries have any kind of speech rights there? The court basically decides no, they do not, that libraries exist to provide information sort of in the way that they want to, not to, and they do this through the internet, but not to allow people the right to speak over the internet. And I won't really get into the details there, but they basically say, oh, I'm out of time. But basically, the court said, that the internet is like in the library is like the technological extension of a book stack. It's not a space in which people are, have any kind of right to speak. So I guess I have to stop there even before I talk about what is to be done. But maybe somebody will ask me. Thanks.